Namaskar, Dilip Singh Advocate. You are most welcome to my channel Journey of Constitution of India. On 21st January 2017, Law Commission organized a consultation program with judicial officers representing from all over the country, and the point of discussion was the laws related to bail. And the venue was Indian Law Commission, Law Institute, New Delhi. It was attended by Justice A.M. Khanwilkar and Justice U.U. Lalit, and it was moderated by Justice Mukta Gupta of Delhi High Court. And the questions related to bail were discussed in detail. The one particular question was, do we need to modify the classification of offences as bailable or non-bailable? And after discussion, it was found that some of the provisions of bailable and non-bailable offences need to be interchanged, or from bailable offences should be given the character of non-bailable, or non-bailable should be bailable. Just such as Section 379 and 498 were specifically discussed, and it was found that these offences be shifted from non-bailable to bailable offences. Whereas the Section 279, 324, 325, 363, 374, 417, 419, 435, 436, 490, etc., and 506 particularly were identified as bailable offence, but it was suggested that this should be shifted to the non-bailable one. Particularly in section of 304A, it was suggested that a classification should be made qua the medical negligence and the corporate related offences. So why I am mentioning this symposium and the consultation of the judges? Because it is high time to revisit the nature of offences as bailable, non-bailable, or cognizable, non-cognizable in the present context. And it needs a detailed discussion, and particularly Law Commission should be given the work to revisit this entire classification. And thankfully, the government is working on it. Friends, you are watching part 3 of the future laws related to bail. And I would request you that please see and watch the part 1 and part 2, which are which will be very fruitful for you before watching this video. And one important recommendation was made by the Law Commission, about which I am discussing, and I have discussed in part 1 and part 2, that there should be consistency between the term of imprisonment and the offences categorized as bailable and non-bailable. Because in some of cases, offences which are having short term of imprisonment, they are characterized as non-bailable, and so this was specifically suggested and recommended by the present Law Commission in its 268th report. Other important point which was discussed by Law Commission was the offences related with economic offences and the bail related with it. Economic offences such as counterfeiting of currency, financial scams, fraud, money laundering, etc. These crimes are of very significance and having impact on serious impact on the economy of the country and national security of the country and governance. So a special recommendation is made by this Law Commission that these economic offences should be treated and should be categorized considering its impact on the economy. So, and even at the time of bail, this gravity of offences and adverse impact of the scam should be considered by the court very seriously before granting the bail. Now, I'll come to the recommendation made by the Law Commission with respect to section 436 and 436A. An explanation is added in the 436 to consider the financial condition of the accused at the time of granting of bail and the fixing of the bail amount. You see, this is suggested to add as an explanation in the 436. There are two other suggestions, and its recommendation strongly recommended in 436A that the two subsections should be inserted in section 436A. These are, first, if under trial is in custody for an offence where the punishment is punishment is till 7 years, then if he has spent in custody for one third of this his total maximum number of punishment, then he should be released on bail on his personal bond with or without surety. The other insertion is as subsection 2 is that if the under trial is in custody for an offence specified more than 7 years but not the capital punishment, then if he has spent one half of the maximum punishment in custody, then he should be released on bail. This will reduce the burden of the prison houses significantly, because as I told you that 67% of the prisoners are under trials, and a significant amount of those who are having of less than 7 years of offences. This now the another important recommendation made by this law commission is that a central intelligence database should be created about the criminal gathering, and this data will be gathered, data should be analyzed, and its data sharing capacity should be increased so that the court, prosecutors, and the police should be in condition to avail the data related with the any criminals at the time when they require. This will increase their efficiency, and they will be able to proceed the matter expeditiously. Law Commission further emphasized that it is the high time to strengthen the crime and criminal tracking network and systems. This crime and criminal tracking network and system CCTNS is very will play a very important role in containing the crime and in the processing and the judicial proceeding. And this should include, particularly this data should include the name, parentage, spouse's name, address, date of birth, as well as Aadhaar card detail, criminal history. So this is the one specific suggestion given by the Law Commission. The other important, very important and timely and very technologically advanced thing is the electronic tagging. And this electronic tagging has the potential to reduce both fugitives who skips the bail and do not surrender, and the government expenditure on tracing them. So this electronic tagging, which is very much prevalent and have been being used in New Zealand particularly for a longer period, it states that, and even there is a provision for electronically monitored bail in New Zealand, and that is if a person is granted bail under this category, then he is given an amulet or an anklet, electronic monitored anklet, which he is supposed to wear 24 hours so that he can be kept under surveillance, and another crime from that person can be prevented easily. So other point which recommended by the law commission and which we need to work, and it which is very timely, is securing the right of the victims. So law commission recommended that where the offence is punishable up to 7 years or more, the victim must be given an opportunity of being heard. And particularly, what is most important suggestion and recommendation by this planning commission, this law commission, is that the prosecution must prepare a victim impact assessment report, and which should be given to the court at the time of filing of the charge sheet. This victim impact assessment report should include information related to physical, mental, and social impact of the crime on the victim, and the impact of the bail on the given to the accused on the victim. So, and particularly in United Kingdom, this system is very much prevalent. A model checklist is prepared, and with every final report or charge sheet, this victim's entire analysis is given, and its impact on the victim is assessed, so that the court should have in its mind at the time of punishment or at the time during the trial that how the victim can be compensated and he can be or she can be heard. The another important suggestions given by this law commission is the risk assessment and risk management at the pre-trial stage. Risk assessment and risk management means balancing the constitutional right of the accused and the risk posed by the accused using effective supervision and strategic interventions. In the risk assessment process, the arrested accused is brought to the station where, after identification, booking, search, questioning, and fingerprinting, community ties are investigated along with a set of predetermined factors. If officer is authorized to release him on personal bond, with procedures say this procedure saves substantial police investigation, police time, investigating authorities time, and the court time, with which also economizes the operation of detention facilities. So let me share here up. So this risk management study is going to be very fruitful for either giving at the bail or and conducting the entire trial in the proper way. Let me share you very interesting finding related to the bail. In a study conducted in 1961 by Vera Institute of Justice, and the name of the project was the Manhattan Bail Project in New York City. After detailed study, it was found that the accused who are having deep root in the society, or having a very a family to support, and a very good family, they, even if they are released on bail without financial security or with financial security, there is a very good possibility of, and there is a possibility of coming and joining the proceeding of the court, because the basic purpose of bail is to secure the participation of the accused in the trial. So this study proved that if an accused who is having a family and a connection in the society, there is very less possibility of fleeing away from the participation in the judicial process. So these laws, this study was also considered by our Supreme Court and referred in the Motilal case as to facilitate the process of granting bail. And that's why, if the entire information of the accused and its impact on the society and victims related, entire informations are given before the court, then the court will be in better condition to dispose of the application and grant the bail, and accused, to ensure that the accused will participating in the trial. So the moral of the story is that judge should have a risk management report, which we need to develop a detailed report so that the judges can critically examine at the time of giving the bail. By this way, if these all recommendations are implemented by the government, then the process of bail will be very simple, and the benefit will go to the accused, and particularly to the poor and ignorant and illiterated accused. Thank you very much for watching this video. Please share the video with your friends and share your view in the comment section of this video. And special request to you, please wish me good luck by subscribing to my channel. Thank you very much. Namaskar.